All right, 7:34 this morning, and it's time to answer some of your legal questions. And you know we always turn to attorney Chris Tritico for that. Good morning to you, sir.
Good morning.
Let's begin with this first question. This is from Emily, who writes, we have a neighbor who has been difficult from day one. We were notified by our tenants in May that the fence we shared with the neighbor was damaged during the derecho. We reached out to him via text. He stated he also had damage to his carport and wanted to run it through insurance. He wanted us to leave it as is until his insurance adjuster was able to see it. We thought it was too dangerous and asked that he submit photos, and he refused unless we wanted to pay the full cost of the fence repair ourselves. We refused as we had paid 100% of the fence in 2016. His adjuster could not see the damage for over 2 weeks. We had a contractor who could start immediately. He still refused to start repairs, and our tenants have dogs. He has small children. We eventually propped it up, and 2 days later, the big storm blew a portion of the damaged section the opposite way into the neighbor's yard. He is now accusing us of intentionally throwing the fence on his crepe myrtle, killing it and causing additional damage to the fence. And now he expects us to pay for this additional fence damage as well as replacing his crepe myrtles. Can he require us to pay for those things?
Well, Emily, he can try, I guess, but it's not something that you did intentionally, and nature did it. His refusal to work with you is really what ended up causing all of this. And at the end of the day, the fence blowing over was not your fault. It just happened. So he can sue you. Anybody can go into court and sue anybody. I don't think at the end of the day a judge or a jury is going to find that you did this on purpose. He ought to calm down and work with you on getting all this done. So I don't think that at the end of the day you're going to be held liable. If he sues you, I imagine your homeowner's policy will cover you for this. But the gut answer to your question is no. He cannot force you to pay for his crepe myrtles any more than you could force him to pay for the damage to your property because the fence blew over. So tell him to calm down and work with you. If he won't, just deal with it. Good luck.
All right, our next question this morning comes from Reggie, who writes, in February, I asked a guy that owns a local nightclub, bar, and restaurant if he was still looking for any extra help. He said he would have to ask his girlfriend since she handles the hiring. A month passed and he told me she was not hiring. In May, I ordered food from his establishment and we speak, and he starts asking me about a food item I brought to his attention, then explains to me that he would not hire me. One is because I'm a male. The other, he claims, is because people don't want to see a big black man bringing their food to them. What should I do?
Well, Reggie, that's horrible and disgusting, and it's discrimination on two fronts. They're discriminating against you because you're male, and they're discriminating against you because you're black. And that violates the federal law. Go to the EEOC, it's downtown, and file a complaint against this establishment. They'll help you fill out the form. You can file the complaint, and they will investigate this and assist you. You don't have to have a lawyer for this, but you can hire one, and you can sue this restaurant if you choose. But go to the EEOC, meet with them, and they will help you fill out the form. You have 300 days from the date of the discrimination to file that complaint with the EEOC. On the 301st day, you are barred from filing that complaint, and you cannot file a lawsuit. So don't let 300 days pass if you truly want to do something about this, and I hope that you do, because you should not take this lying down. Good luck.
Yeah, I hope he gets some help too. That's crazy.
Yeah, that should not last. That should not stand.
All right, our final question this morning comes from Maria, who writes, when I purchased my new 2019 Ford truck, I also purchased an extended warranty for 6 years or 100,000 miles that expires on the 4th of July, 2025. The service company and administrator sent a letter saying they have been advised there may be a price increase to extend vehicle service plans. Can this company ask me for more money in order to honor the service contract? What should I do with this one?
So, Maria, I can't tell from your email if what they're telling you is there is a rise in the fees for when you bring it in, and they're just, for every time you come in, there's a fee for the service. If that's what they're doing, raising that fee, it's probably okay. If there's some kind of a monthly charge for this service contract, I don't know of those, but if that's what they're doing, probably no. They cannot do that based on the contract. You need to read the contract, reread the letter that you got, and make sure what it is they're raising the fee for, and check out your contract that you enter with them and see if it's barred by the contract, and make sure that you know exactly what you're objecting to. But no, I don't think that they can do that if they are raising the fee that you agreed to in the beginning. If that's the case, write them a certified letter and tell them you're not agreeing to this. It's a breach of contract. At the end of the day, I think you should go and consult with the lawyer of your choice, let them look over everything, and make sure that you're correct before you take action. Good luck.
Always helping us with our legal issues. Chris Tritico, we appreciate you as always.
Bet.
And we appreciate you as well. If you want to send us your legal questions, just head to our website, fox26houston.com. You can find Chris's segments under the Morning News tab. And as always, for specific info and advice, contact an attorney of your choice. We're going to head to break. We'll be back after this.
See you.